Dear colleagues, distinguished audience, it is my pleasure to welcome you today to the Central European Talk series. My name is Noémi Nagy. I'm Senior Lecturer at the University of Public Service, Budapest, Hungary. Today I'm going to talk about how effectively the Constitutional Court of Hungary protects national minorities. Is it a strong bastion of minority interests, or rather a ramshackle cottage? So let's start at the beginning. One of the most important, deep-rooted and sensitive political issues of Central Europe is that of national minorities, otherwise referred to as nationalities. These groups have historical presence on the territory of the state. They share ethnic, religious, or linguistic characteristics that are different from the rest of the population, and they want to preserve these characteristics. The protection of the rights of national minorities is primarily the responsibility of the state in whose territory the given minority lives. This protection is complemented by a multi-level system of international law. Naturally, these two legal systems are not independent from one another. International standards adopted under the auspices of intergovernmental organizations have gradually been incorporated into the constitutions and laws of Central European countries, including Hungary. Hungary, a multinational state for 1,000 years, is now home to 13 national minorities. The Roma, Germans, Romanians, Slovaks, Croats, Serbs, Ukrainians, Poles, Bulgarians, Greeks, Ruthenians, Armenians, and Slovenes. Altogether, they make up approximately 6.5% of the population, according to official census data, counting some 650,000 people. In terms of legal framework, after the democratic transition in 1989, Hungary's new law on the protection of minorities became generally praised as standard-setting in Europe. In 2011, a new constitution and a new law on minorities were adopted, which overall preserved the relatively strong legal framework for the protection of national minorities. However, legal provisions are one thing, and their practical implementation is another. We all too often face this fact in the course of the various monitoring procedures by international and national expert bodies. In Central Europe, and in most democratic countries elsewhere, the ultimate protection of minorities is the responsibility of a constitutional court. This means that the normative interpretation and the effective implementation of minority rights largely depend on this supreme judicial body. The court's opinions, combined by judgments on minority issues, may have a strong influence on how minority rights are perceived and valued by the legal scholarship, as well as practitioners or even by the public. So the question I seek to answer in this talk is the following. Are minority rights in Hungary effectively protected by the Constitutional Court or not? In order to answer this question, I looked through all court cases relevant to the minority issue. It's not a terribly high number. We are talking about some 40 cases out of the 10,000 for which the court rendered a decision during its operation. The Constitutional Court of Hungary itself is a product of the democratic transition. It was established in 1989. Its powers are basically the same as those of any other constitutional courts or Supreme Courts fulfilling a constitutional function, such as the Supreme Court of Canada. These powers include the constitutional review of legislation, the interpretation of constitutional provisions, deciding individual complaints, and so on. I'm sure that many of you are aware of the political and legal changes performed by the current government of Hungary. These changes also affected the composition, the powers, and the procedure of the Constitutional Court, which many scholars find troublesome. Some speak of party-line constitutional justice, the twilight of constitutionality, or the loss of the constitutional role of the court. Interestingly, on the basis of my review of the relevant case law, it seems that the Constitutional Court's approach towards minority rights has been unaffected by these developments. Unfortunately, there has been little emphasis on the protection of minorities in the court's practice, both before and after the legal reforms. Now, I'm not going to analyze all the 40-some cases one by one, but I would like you to have an overall picture of them. There are basically three main issues that these judgments deal with. First, what is a minority? That is, what does the term minority mean, and which ethnic groups seeking recognition can be considered minorities? Second, who belongs to a minority? That is, who is to be recognized as a right holder of minority rights, and what are the rules for minority self-identification? And third, what are minority rights? This means the exploration of the content of specific rights for persons belonging to minorities set out in the Constitution, the Minorities Act, and other legislation, including the right to representation of minorities, the right to participate in public affairs, and certain language rights. Today I'm going to share with you a few conclusions regarding the first two issues, and one specific minority right, the right to representation through the minority self-government system. Regarding the first issue, the concept of minority, the Constitution itself only says that national minorities are constituent parts of the state. The details of the definition are left to a separate law, the so-called Minorities Act. This law says that, quote, all ethnic groups resident in Hungary for at least 1 century are nationalities, which are in numerical minority amongst the population of the state, are distinguished from the rest of the population by their own language, culture, and traditions, and manifest a sense of cohesion that is aimed at the preservation of these and at the expression and protection of the interests of their historically established communities. End of quote. The annex to the law contains a list of the 13 ethnic groups I just mentioned that are currently recognized as nationalities. This list is not closed because those concerned are allowed to initiate their recognition as a nationality. There is a special procedure for that, which entails the collection of 1,000 signatures and the decision of Parliament. The court encountered this issue in regards to the Jews, the Russians, the Bunyavaks, and the quite absurd case of the Huns. Each time it remained silent on the content of the statutory conditions for being a minority. Instead of giving an interpretation of its own, it used circular reasoning, conveniently relying on the definition of the Minorities Act. Then again, the Minorities Act is inferior to the Constitution, so it is absolutely possible that it contains rules that are unconstitutional. After all, it is for the Constitutional Court to interpret constitutional provisions, including the concept of national minorities. So we don't know whether the Jews, the Russians, the Bunyavaks, or the Huns would qualify as national minorities in view of the court. We only know that, so far, initiatives for the recognition of these groups have been unsuccessful, either because they did not manage to collect the necessary number of signatures, or they did collect them, but the Parliament refused to recognize them anyway. As for the question of who belongs to a minority, this becomes interesting when a person wants to exercise a minority right. For example, the right to representation, which already leads us to our third topic. One of the possible ways that minority groups can realize their right to representation and participation in public affairs is the establishment of minority self-governments. In Hungary, the system of minority self-governments is based on the model of personal autonomy. This means that minority bodies are elected only by those belonging to the given minority, and the power of these bodies extends only to the minority. In Hungary, we have a three-layered system. Minority self-governments can be established at the local, regional, and national level. The powers of these bodies are mostly restricted to the fields of education, culture, and media. Hungary's previous regulation on minorities did not contain any rules on formal identification of minority voters, and it was so vague that it allowed anyone to participate in the elections of minority self-governments. So not only persons belonging to the given minority who considered themselves as such, but practically anyone could vote and be elected. National and international media was bursting with news on ethno-business and the so-called cuckoo phenomenon. During the 2002-2003 elections, there were so many abuses in relation to all minority groups that the Constitutional Court was eventually requested to interpret the relevant provisions of the Constitution. Surprise, surprise, the court rejected the first petition on this issue for formal reasons. Shortly after that, the Parliament amended the relevant laws and introduced the institution of minority registration. This means that if you want to vote at the election of the local German government, for example, you first have to register yourself on the German minorities electoral roll. However, even against this background, the Minorities Ombudsman considered the situation unconstitutional and filed another petition with the Constitutional Court. In his view, the new law failed to guarantee the truthfulness of declarations on minority affiliation, nor did it provide for sanctions in case of false declarations. This time, the Constitutional Court could not avoid addressing the problem head-on. In light of its decision, minority affiliation is closely related to the right to self-determination and ultimately the right to human dignity. The institution of minority registration, that is, disclosure of personal data related to minority affiliation, is subject to the consent of the individual. However, the right to self-determination may be restricted and individuals may be obliged to declare their affiliation with a minority group if the restriction is justified. Justified how? By compelling reasons in the protection of other constitutional rights and values, subject to the principles of necessity and proportionality. In this case, the other competing constitutional right was the right to establish minority self-governments. The court said that, quote, "The minority electoral roll is based on the right of minorities to self-determination. Registration on it is based on the voluntary free choice of individuals belonging to a given minority. The list is not public, and it is a condition for holding minority self-government elections. The electoral roll is but one option to realize the right of minorities to establish their self-governments as provided for by Article 68, Paragraph 4 of the then Constitution. The minority electoral roll is a guarantee thereof." End of quote. As for the details, the court basically gave a free hand to the Parliament. But the story doesn't stop here. In accordance with the new Minorities Act adopted in 2011, the exercise of certain minority rights became conditional upon a specific number or proportion of persons belonging to a given minority group. Whether this number or proportion is reached is to be decided according to the data of the latest census. Originally, this rule applied to certain language rights and the establishment of local minority self-governments. So what does this mean exactly? Up until just last year, election of local minority self-governments could be held only where there were at least 25 people belonging to a given minority, again according to the latest census. This regulation was of course severely criticized. The Minorities Ombudsman, for example, pointed out that census data cannot be regarded as an accurate representation of the minority population of a village or town, since these data are based on voluntary declarations. In addition, it is of serious concern that at the time of the data collection of the latest census, it was not known what consequences the declaration of minority affiliation would have for the exercise of minority rights. So what did the Constitutional Court say about that? Listen to the cynicism of the judgment. Quote, "The Constitutional Court has noted that even before carrying out the census in 2010, the government indicated that it would attach a much greater role to the census data. In fact, it would take it as a starting point for its actions." End of quote. In sum, the court decided that connecting the establishment of minority self-governments to census data does not violate the individual right to self-determination. On the contrary, this may encourage citizens belonging to minorities to exercise their right to minority self-identification. So much for legal reasoning. But the story is still not over. The legislation, once again, was amended by the parliament, this time in favor of minorities. Now the rule is the following. In case there are less than 25 persons belonging to a given minority in a village or town, but the relevant national minority self-government, so the top-level minority body, considers that self-administration of a local minority community is necessary, then minority elections can be held there. Yay! Mind you, the Constitutional Court had nothing to do with the turn of events. It was all decided at the political level. In case the current regulation was challenged in front of the court, we can be pretty sure that the court would say, everything is fine, the rules are in harmony with the Constitution, and anyhow, the legislator, the parliament, has a wide margin of appreciation in regulating the matter. Unfortunately, we have no time to discuss other issues now, but I hope I have managed to reveal a few patterns in the minority-related jurisprudence of the Constitutional Court of Hungary. The first two issues, that is the identification of minority groups and persons belonging to these groups, are unavoidable, logical first steps in the process of exercising minority rights. If the law is not clear about the so-called personal scope of legal protection, then the rights themselves become meaningless. This is where one would expect the Constitutional Court to take a firm stance to guide the legislator in developing the detailed legal framework. However, based on my research, I have come to the conclusion that the general attitude of the court towards minorities is driven by a complete lack of judicial activism. The court has avoided substantive examination, that is, to examine the merits of a complaint, whenever possible. Many times, the arguments it has used seem to be excuses instead. The court rejected many petitions and complaints because allegedly they did not contain a specific constitutional problem, or the regulation of the matter in question belonged to the legislator's competence, or it was not up to the court to deal with practical issues. To conclude, the Constitutional Court of Hungary has failed to provide a constitutional interpretation of the concept of minorities. It has given no precise guidelines on how to identify persons belonging to national minorities, and it has also failed to define the constitutional minimum standards for the exercise of minority rights. All this calls into question the role of this highly prestigious judicial body as the supreme guardian of minority rights in Hungary. I hope you found this talk interesting and useful. If you'd like to know more about this topic, please contact the organizers of the Central European Talk series. They can connect us. Thank you for your kind attention. Have a nice day.